All right, good afternoon, everyone. Let's go ahead and get started. Thank you for being here today. So for those of you who don't know me, my name is Lee Reiners. I'm the Executive Director of the Global Financial Market Center here at Duke Law. Oh, hold your applause. He's on our board, so he has to clap. But today we are very fortunate to be joined by Katharina Pistor, fresh from Davos, Switzerland, where she spoke on several panels at the annual gathering of the World Economic Forum. So we appreciate her making time for us. Katharina is the Edwin B. Parker Professor of Comparative Law at Columbia Law School and Director of the Law School Center on Global Legal Transformation. Her work spans comparative law and corporate governance, law and finance, and law and development. Today, she is here to speak about her excellent new book, The Code of Capital, How the Law Creates Wealth and Inequality. And I saw we have a table set up outside selling books, and Katharina's graciously agreed to sign some copies afterwards, so encourage you all to go out and buy a copy. The book argues that what we think of as capital is coded in the law, that lawyers are the masters of this code, and that most master coders originate from elite law schools like this and common law legal systems. So we'll leave 15 minutes or so at the end for Q&A, but for now, please join me in welcoming Katharina to Duke Law.
Hang on, does this work? Can you hear me in the back? Okay, great. If it fades for some reason because my jacket changes or something, do let me know. So, well, thank you so much for having me today. Really appreciate it, and thanks for the kind introduction. I will give you an overview of the argument of the book. I will only focus on one of the chapters because I don't want to overload us. I'd much rather have your questions and clarify them at the end. So let me give you just basically the thrust of the argument. Here's the Code of Capital. The blue, of course, sort of the lines are suggesting what the code is all about. So when I talk about code in this context, I'm not talking about the big codifications like the civil code in France or the BGB, the civil code in Germany, but I'm talking about the process of coding, and I'm thinking more software coding or genetic code than the legal code. So you can use either metaphor, software coding, or the genetic code. None is a perfect fit, but I think it tells you a little bit more than the idea of the big codification, the big codices that we see in the law. So here's the argument in a nutshell. So I'm basically asking the question again, what actually is capital? And many of you might have read Thomas Piketty's book, Capital in the 21st Century, where he basically says, well, capital is, I equate it with wealth, and wealth, he basically says, are non-personal types of assets, and then lists all kinds of different assets, and many other economists follow him in that. There are, of course, other definitions of capital as well. We can think about capital as one of the two factors of production next to labor. That's a very conventional ways in which many economists would think about capital. Karl Marx, of course, said capital is a social relation. It's certainly not a thing, it's a social relation. And I'm saying, yes, it's a social relation, but it's a social relation of a particular kind. And in fact, it's a trilateral relationship. I'm basically saying it's an asset holder, other people, and then there's the state that makes sure that the interests of the asset holders are protected. And you can't think about capital without the state because capital is coded in law. So I'm basically saying capital is an asset of a particular kind, right? There are ordinary assets or ordinary objects, and there's capital, capital assets. Essentially, I'm saying, give me any object, like a piece of land, or a movable object, or a promise of future payments, or an idea, some know-how, and with the right legal coding, I can flip these simple things into a wealth-generating asset, which is a capital asset. And that's critical for understanding how capitalism has evolved and for why some people get richer than others, because if we were all just exposed to the ups and downs of economic cycles, we would not see the accumulation of wealth that we have seen over time. So what distinguishes a capital asset from an ordinary asset? There are four attributes, or really three. I will explain why there are three, but I'm listing here four. One is what law does with assets. It creates a rank order. It prioritizes some claims over others. And the place to look to really know who has stronger rights and who has weaker rights is bankruptcy, right? In bankruptcy, by definition, the debtor has fewer assets than there are claims against him or against the asset pool. So then we're starting to rank. Does anybody own something that is in the pool? That person could take it out. Property rights trump everything else. Is anybody secured? If you have a secured interest, you have a stronger rights than everybody else. And if you don't have a secured interest, then you are one of the many unsecured creditors, and you probably suffer a major haircut, right? So priority is key for having a capital asset. The second is durability, and durability extends these kind of interests in time. It protects assets in time, over time. And classic examples for that, I'll talk about this a little bit more in a little while, are corporate entities or trusts that basically create a legal veil around a pool of asset and protect that pool from too many different kinds of creditors. The third element that you need is universality, which means is that these priority rights that we're creating and the durability interests that we're creating are enforceable not only against contracting parties in a bilateral fashion, but they're really multilateral or universal. They are enforceable against the world, ergo omnes, as we like to say in Latinese, in the legal verbiage. And then last but not least, there's convertibility. And by convertibility, I mean not simply tradability or assignability, but the ability to flip an asset I currently hold into an asset that is safer. So in a way, and it's really important for financial assets, because when you think about financial assets, when things get rough, what does everybody want? Dollars. Why does everybody want dollars and not some kind of toxic asset, some kind of derivative or a securitized asset or something like that? It's because only state-issued legal tender retains its nominal value. Not necessarily its real value, it can have inflation. But having the nominal value protected can matter a lot in times of crisis, right? And when you have convertibility, when you have a put option to the central bank, or when you can create a put option so that the state will bail you out, you basically have an option to lock in your past gains before they might dissipate because of a financial crisis or something like that. So convertibility is really the way in which you can create durability for financial assets, right? So you need three of these four attributes to create capital. So that then brings me to what I call the legal module. So I talked before about the fact that I think about the code as a software code or a genetic code. So you can think of the legal institutions as either elements in a genetic code or modules in a software code. And the core legal institutions that I argue in the book have created capital for the most part over the last 400 years or so are property law, collateral law, trust, corporate law, bankruptcy law, and contract law, which sort of fixes some of these things, sometimes mimics the other rights and interests. But these are actually the core institutions that have been used to code different types of assets as capital over time. What I found most remarkable and what basically made me write this book is how constant these legal institutions are. And of course, the fact that these legal institutions are all institutions of private law. Right? So it's not regulatory law, but it's the private law that people can use and that lawyers can make malleable to adapt it to the needs of their clients in the expectation that whatever they do, whatever transaction they code, will be enforceable in a court of law. It doesn't always work. Sometimes it's not enforceable, but in the expectation that you can enforce it in a court of law, because you have that expectation, people will actually buy these assets or will pay a premium to buy these assets. And I'm basically saying, especially in anonymous large-scale markets, you can't do without that. You can't sell the stuff in an anonymous market unless the other party can only look at the asset itself and know whatever rights are embodied in those assets are in principle enforceable. You don't necessarily have to use the enforceability, you don't have to exercise it, and maybe sometimes, as I said, you might lose, but even in the expectation that it's enforceable, you can already make a lot of money on them. Okay, so what is important here, and this brings me to emphasize again the importance of private law over public law in the coding of capital. I'm not saying that public law doesn't matter at all, but I think it's really important to realize the importance of private law. People very often think, especially non-lawyers, think about the law as a top-down way in which states order their societies, tell citizens what to do, what not to do, through criminal law, through regulatory law, etc. Then there's, of course, the bottom-up way in which people who do constitutional law, civil rights, and human rights think about the law as a way in which individuals can use the law and hold it against the state, which is a remarkable thing when you think about it. The state empowers individuals to actually protect themselves against the state with a law that is ultimately of the state, right? And these are important dimensions of legal systems, but what I really want to emphasize is the horizontal dimensions. The way in which private individuals can avail themselves of the institutions of private law to order their horizontal affairs. That's what markets are all about, right? Of course, there can be small markets, there can be spot relations where you don't need any law and nothing like that. But any market of some scale and of some complexity cannot do without some kind of an authority that stands in the background and says, whatever you agree on will be enforceable in the law. And if you really want to have a binding enforceable agreement, you better make sure that it is legal, right? Which is why I call my first chapter Empire of Law. It's critical to be legal. If it's illegal and void, you can't enforce it, it loses its luster, right? So all the coding techniques and strategies that the masters of the code do make sure that they try to at least get around certain legal constraints, and you use these institutions to do so. So when I talk to my lawyers friends in the city of New York, they basically say we can almost mute any public regulation with these vehicles, with these tools, right? There's a toolkit you can use. It takes a little bit of time, it gets a little bit more complicated the longer or the more complex the regulations are, but effectively we can mute almost every public regulation with the help of these elements. And I think that's really important to realize. It's also law. It is law, and we wouldn't have a market economy or capitalist system without that law. But it's law and it's backed by the state, and ultimately it's us who back it. And I'll come back to that when we talk about the political economy. So in the book, I talk basically about 4 types of assets that have been coded as capital over time. I start with land, everything, all the core institutions that we're talking about, property rights, collateral law, in particular also trust, the common law trust in England, all evolved in relationship to land back in the days of feudalism, right? Others, bankruptcy law comes into play much later. The first bankruptcy code in England is of 1705. In many other countries, they were adopted only in the 19th century. Corporate law is the creature of the 19th century, right? But the core institutions are older than that. And so I talk about land, I talk about firms, business organizations, I talk about debt, and I talk about know-how. I don't really talk about data in this book. It's actually one of my current research projects, and I'm happy to respond to questions because, of course, many people are saying data is the new oil. And so the question then is, how important is the good old legal code for these types of assets, or can they actually do without the law, just with the digital code rather than the legal code, right? That's sort of one of the questions I'm wrestling with right now. I do have a chapter in the book that asks the question whether the digital code could replace the legal code. And I'm talking mostly about cryptocurrencies or digital currencies in that chapter. And in the end, come out and say, probably not. Probably the legal code will enclose the digital code. But I have to say, I finished the book in the fall of 2018 after Libra and all the rest. I'm not so sure about this anymore, right? So this is, again, subject to discussion. Okay, so I thought what I'll do is I'll just talk to you a little bit about the chapter on how debt is coded as capital, basically how you can mint debt or how you can mint new financial assets that you can sell for profit in the market and thereby create your own capital with the help of private law. And then I'll talk a little bit about globalization, about the masters of the code, the lawyers, all of us here, and about the implications of all of the above for the political economy that is for us as also societies that wish to govern themselves democratically, that is by self-governance and how this meshes with the broader story I have in the book. So here's basically what I just want to point out, and many of you are familiar with that. This is basically a securitization structure with a CDO structure on top of it. And I'm using documents that were made published by the Financial Crisis Inquiry Commission after the major crisis, so you can look this all up. One of the things, of course, of these new the structured financial markets is when you have private placements, you can't easily get all the documentation that you need to see what they really agreed on. Even the central banks who were buying all these toxic assets never had their contracts. I was trying to get it from them. So you have to find the lawyers, and some will give you some of the documentation, but it's easier to take the public ones. So this is a simple structure. In the upper right-hand corner or left-hand corner from your side, you see the little houses. These are the homeowners in California, right? They want to buy a house and they need a loan. In order to get a loan, they have to give a mortgage. New Century is the originator of these mortgages. New Century is one of the first intermediaries that went belly up already in April of 2007 or so. So spring 2007, they went under. What they did at the time is they were basically originating a lot of mortgages, thousands of them. And typically, they did this after the bank said, we would need more of this stuff, right? So very often we think about homeowners being the ones who are basically pushing it because they need money for houses they can't really afford. I think at some point in the 1990s, the picture flipped. And what was clear, what the industry was trying to do is create assets for the financial sector, assets for which they could find demand. And so you see then the dynamic that New Century is going out and trying to give homeowners these mortgages. Once they have thousands of them together, they sell them wholesale to a financial intermediary, in this case to Citigroup, or more precisely to one affiliate of Citi, the holding company that basically is positioned to buy wholesale all these mortgages, and then act as a sponsor of a new trust they put together. So the real key issue here is the RMBS trust. In the middle, these little flags indicate the different legal jurisdictions that we're talking about. I should have done California up there as well. So we have California property rights. We're selling it to Citi. Citi is a New York entity, and it establishes a trust also governed by the state of New York law. All of these things now go into the trust. The trust is, of course, an interesting legal vehicle. It's a brainless creature, but it separates these assets from Citi. So whoever now buys an interest in the future cash flows on these mortgages doesn't have to think about its exposure to Citigroup or any of its affiliates because the trust protects them from that. That's what we call the true sale. You shift all the stuff into the trust. And then the different investors are buying interest in those trusts. So these are the beneficiaries in a trust scenario who buy interest into this trust. Now, originally, in the first iteration of securitization, when Ginnie Mae or Fannie Mae were doing the securitizations, they created very simple trust structures. You just basically throw all the assets into one trust, and then everybody gets the same cross-section of these cash flow rights that they manifest, but only just some get a bigger slice and others get a smaller slice, right? When the private sector took over securitization, it's now Citigroup doing the securitization, they want more investors being able to buy this stuff, and so they want to create cash flow rights for different types of investors. Some get more secure interest, and some get less secure interest. You are either a senior holder of a tranche, or you are a junior holder of a tranche. So we're tranching, we're cutting these cash flow rights in different ways. So if you're senior, you're always the first one to get the cash that comes in, always the last to suffer any losses if the cash does not come in. If you're junior, it's just the reverse, right? That's how we structure this. So these are basically contractual structures that create priority rights. So I tell you again sort of my attributes, right? Priority rights, this time contractually, right? And they tell you exactly sort of what you have to pay for that in order to get these kind of rights. So for the senior tranches, it's relatively easy to find buyers. Fannie Mae, which used to be a mortgage securitizer, an important securitizer, Fannie Mae buys the super senior tranche here. So the government-sponsored entities are no longer doing the securitization. The private sector now does it, but they're participating and they are fueling a lot of money into these structures because they can borrow money on below market rates on global credit markets because they have an implicit government guarantee, right? So they're basically fueling the money into that. Fannie Mae buys here. Other entities that buy supers or senior tranches are the China Investment Corporation, which is China's sovereign wealth fund. There's Bayerische Landesbank, one of the state-owned banks in Germany. There's BNP Paribas, a French private bank that joined the party of securitization and structured finance relatively late with a fund only in 2005 or so. Okay, and then you have some who want to buy the junior tranches because they like risk, so they get greater returns, right? But of course it's risky, but that's just the deal that you cut, and they would like to have that. The tranches that were most difficult to place typically were the lower mezzanine tranches. They were not risky enough for the risk-loving investors, and they were too risky for those that were looking for safety. But if you can't place all the tranches, you can't really close the securitization structure, and then the whole scheme doesn't work, because the whole scheme is doing this on a mass scale, right? To doing one after the other and to place all these tranches. So what the industry figured out what they had to do is basically they had to invent their own buyers for the lower mezzanine tranches, and that gave us the collateralized debt obligation. You simply set up another legal vehicle, this time in the Cayman Island. And actually, Claros was the name of this vehicle. It had a twin brother in Delaware, or sister. That's a sibling in Delaware called Claros II. And the reason for Claros II in Delaware was that insurance companies could not buy too many foreign assets. They had a quota for foreign assets. But if you were a co-issuer, Delaware co-issuer with a Cayman Island issuer, then you could sell to the insurance company because the regulator said that's okay, because it's no longer foreign, it's a foreign asset. Okay, so the CDO is now in Cayman Islands. You understand why it's in Cayman Islands, because it gets certain tax benefits. And then they go out, this company goes out and raises funds. It doesn't have any funds of its own. It basically has a capital of $2,000 when it's first set up. So it goes out and raises funds from investors saying, we will buy mezzanine securitization tranches from lots of different securitization structures, not only from this RMBS trust, but from many others as well. And because it's so diversified, the likelihood that all of them will tank at the same time is almost close to zero, which is why we can actually tranche the assets again. We can tranche the cash flow interest in this structure again. So we have some super senior note holders and some junior note holders. And again, we have some mezzanine note holders. And what do we do when we can't place the mezzanine note holders? Well, we do the whole thing again. This is then basically we're creating a CDO squared. If we can't place those tranches again, we do a CDO cubed and so forth. And the industry did that. So this is what happened. Just to be clear, what I'm telling you here is basically we're creating financial assets that find takers, people who really pay money for that in the expectation of future cash flows. And they do this because these rights are dressed up with certain legal protections, right? You have the trust, because the trust separates the risk of the trust sponsor city from the assets in the trust. So the investors can only look at the cash flow rights in the trust, and if you get the right rating from the rating agencies, you're sort of fine, especially if you're a senior one. And then so you have different entities. They all have their own legal structure, nationality, of course, as well. But then you have another entity, this time a limited liability company that does basically the CDO structure. So you have everything from land ownership, property rights. You have contractually created priority rights that look like collateral, are not technically collateral, but close to that. There's always, of course, the question looming in the background is whether any of these investors could ever enforce against the houses on the other side, right? So there are interesting legal problems here. Who actually has the right against the homeowner to evict the homeowner? There were also interesting litigation after the crisis that we can talk about. But you get basically all the elements that I was talking about. You have priority rights, you have durability, the trust, the corporation gives you durability. Universality is baked into private law because the state basically commits to enforce the rights that are created thereunder. If it didn't, this whole thing would not work. And then you have convertibility that depends. I think you could argue that Fannie Mae, the China Investment Corporation, some of these banks have a put option to their own central banks or to the public if things go wrong. It's basically all built into it. Okay, so one of the things that you saw here with all the little flags is this whole thing actually was not a national US-based thing alone, but it was a global thing. And one of the interesting puzzles, of course, you could pose, or challenges that you could pose to me, is that I'm saying capital is coded in law, right? And the law that I'm mentioning is all private law, and private law is domestic law. We don't have a whole lot transnational private law, right? In the EU, we have a little bit more, but even there, not very much. So how is it that we can have a global capitalist system, all these different nationalities participating in this scheme alone, without a global legal system and without a global state? Does that not undermine my entire argument? Should be a question that you might have on your minds? And my answer to that question brings me back to this slide, is in theory, we could have a global capitalist system that is sustained by a single legal system, as long as all other legal systems respect and enforce the rights that are created under that first legal system. In fact, we have not one but two legal systems that do most of the work here: the laws of the state of New York and English law. Right? You can add Delaware for corporate law for good measure, but most of the financial assets are coded either in London or in New York, and it works only because we have this second set of rules that hardly anybody talks about anymore. We no longer teach conflict of laws at Columbia as a full class. It's mentioned in CivPro and some other classes, but it's given less attention than it deserves. But this is all about conflict of law rules, much more so than harmonization or international treaties. There are some treaties, of course, right? But most of this works because we have conflict of law rules that basically allow private parties to pick and choose from among legal systems the ones they want, and the ones that have proved to be most amenable to the interests of capital are the laws of England and of the state of New York. So there's also an interesting aspect for political economy, to which I will come back later. There are rule makers and there are rule takers. And even the jurisdictions that are rule makers, even most people who live in those jurisdictions might not realize how important their law is, not for themselves, but for others as well. So I gave you the puzzle already. This is basically the conflict of law. And the one thing that I want to add here is that we have expanded the choice of private parties in conflict of law matters quite considerably over the last several decades. We could always choose the law that governs our contracts. Even if neither of the parties was from a particular jurisdiction, they could still say it's Swiss law because Swiss law sounds neutral or it's a different legal system. For property rights, however, the principle was usually it is the law of the state where the asset is located. So it's very territorial, it's very sovereign, determined what property rights, what laws shall govern property rights. But what do you do with assets that have no location, such as financial assets? For that, we invented a new nexus, a new conflict of law principle, which says that the law shall govern financial assets of either the choice that the account manager and the account holder make, which is contractual, right? We're now flipping property rights into contractual determination, or it's determined by the jurisdiction in which the issuer is located. Now, the jurisdiction in which the issuer is located can also be manipulated because we've basically done away in corporate law with the so-called seat theory and have given parties the option to basically choose the jurisdiction in which they wish to be incorporated, with the effect that almost every other jurisdiction in the world will recognize these legal creatures if they follow the rules of a different jurisdiction than their own, and will recognize them as legal entities with all the bells and whistles that come with that, right? So the fact that we have allowed choice of law basically for incorporation also means that we in financial assets now have choice of law for property rights as well. And that makes this feasible. It makes it feasible that we can have a global system that is sustained for the most part by two legal systems. You see this very explicitly when you look into some of the global master agreements. Some of you might have heard about the International Swaps and Derivatives Association that created a master agreement for all derivatives and repos that most of the entities that transact in these kind of instruments use. And the master agreement basically says, choose either English law or New York law in the courts of England or the courts of New York. And in the comment says, if you don't do this, you will be doomed, because other courts and other jurisdictions might not understand what you're talking about. Okay, so we know, of course, that New York and London are the two largest financial centers. New York has gotten a little bit of comparative advantage now, with London being immersed in all the Brexit discussion. And of course, there are other centers that are emerging as well. Singapore, Shenzhen, Hong Kong might be declining, as you know. So it's not necessarily written in stone that these will be the most important financial centers forever, but they still are today. And everybody knows that to some extent. What is less talked about is this, is that the 100 global law firms, top global law firms, and a global law firm is a law firm that has offices in more than one jurisdiction. The largest global law firms, top 100, are all Anglo-Saxon, and they all sit in London and New York. So London and New York are not only the global financial centers, they're also the global legal centers. That's where capital is coded, right? And when you look into some jurisdictions like France or Germany, significant economies as well, in areas such as capital market law or mergers and acquisitions, the domestic firms that have not merged with either an English or American firm have a very small market share. So 2/3 of these markets are typically in the hands of Anglo-Saxon firms as well. So in some way, you could say that the globalization of capital is a globalization of legal practices that come from the Anglo-Saxon world. Maybe you could even go a step further, and it's very, very much driven by American law and lawyers, but also by English ones. So you can see that. I only gave you the top 20, but I could have given you the top 100, and it just looks very similar. So let me then come basically to the tension that I think this creates. So once you understand the system as, capital as a system that is coded in law, where basically private parties can avail themselves of law. It is law after all, and law is critical here. Because only with the assurance of enforceability can I create really wealth-creating assets. Otherwise, I might be lucky, I can make a big scoop in one transaction or so, but to retain this value over time, to make sure that I have priority rights over others, that others will respect that, I need law, and I need a state. Not necessarily my state, though, right? I could have another state if I can opt into another law, and my state respects that. I need a state. But the fact that we can now switch and pick and choose from different states, we can switch from one legal system into another one, basically means that the relationship between those who code capital or benefit from the coding of capital to a particular legal system is more attenuated because they have some variation from which they can pick and choose. So the fundamental tension then is, how do we square that? Global capitalism as a system in which you have a menu of different legal systems, you pick and choose. Yes, we see, in fact, that they pick typically 2 jurisdictions, but these jurisdictions also have proven time and again of being very amenable to capital. And they could easily switch into some other jurisdictions if another jurisdiction offered a little bit more. But how do we square that with our idea of we the people? We want to self-govern. We want to set the norms for how things are done in our societies. If some of the most important transactions and the most important players, economically speaking, opt into different legal systems or use this law only under the condition, contingently, that it fulfills their need, otherwise they will opt into another one. And I'm basically saying, that we have a problem here because democracies govern themselves by law. We don't have another tool to do so, right? Capital is coded in law, but also democracies govern themselves by law. And what we also need to retain is the authority of the law, the legitimacy of this ordering device without which neither capitalism can survive nor our democracies can survive. And what I'm saying, in effect, is that the extent to which private parties have been able to now sort of gain not only access, but almost control over the legal coding devices and use them to benefit themselves has gone too far. I'm not saying throw it all out, but I'm saying we just have to push it too far, and we need to make sure that democratically governed societies in particular have some ways of governing themselves. So we have to roll this back. In the final chapter on the book, I'm basically suggesting, I'm starting off with a sentence that sometimes people use as a critique of the book. I'm saying basically capital rules and it rules by law. So now I'm giving capital the agency. I've denied it earlier, but that's basically the point. And so I'm saying, well, so how do we basically balance these two things? So I'm not saying just kill it all. I'm not saying I want to go back to socialism. I studied socialism for too many years in the 1990s to be wanting to do that. I'm sure there are different versions of socialism. We can discuss that. But I'm not saying that. What I'm actually saying is let's have a real market. We don't need an economy that is on legal steroids and is so biased for holders of capital that actually have access to coding strategies that nobody else has access to. You have to have access to the really well-paid lawyers, right? Otherwise, you can't win here, right? It's this very stratified society. So what shall we do? And what I'm basically saying in this final chapter, of course, much more research has to be done, much better strategies have to be developed, but some ground rules here. First, okay, you already have a lot of privileges when you have access to the coding of capital, right? Priority rights, durability, universality, convertibility. Okay, let's just have a flat rule and say no more exemptions from anything else. No bankruptcy safe harbors or safe harbor for anything. What is a safe harbor? Safe harbor basically says some will be exempted from the rules that apply to everybody else. Why do that? We don't need to do that. Of course, there are always good arguments made for derivatives. We exempted them from bankruptcy rules. It turns out in the financial crisis it wasn't such a great idea. It turned also out to be incredibly difficult to roll this back. So let's just work by that flat rule, and if you want to revise that rule, then maybe the burden's on you to suggest why actually this you get so much, not only the private interest, but society gains so much from a deviation of that principle that we should be doing it. Right? Then I also saying we should probably limit the choice of law to some extent. Choice of law for contracts yet? Yes, for everything else, including corporations, let's think again. Or you could modify this again and you can use something that many states have in this country, but the extent to which they can apply it is sort of disputed. But the foreign company provisions in your corporate statute, even Delaware has some of them, every state has them. And foreign is, of course, also a corporation from a different state in this country. So maybe states have the power to impose some other conditions on their corporations, and we should enforce that and respect that. Another thing that I think we should think about again is arbitration. Right? We do an increasingly amount of arbitration, private dispute settlement with private arbiters, with the effect that courts will enforce the ruling without checking the merits of the ruling, both domestically and transnationally, right? And that's all backed by the New York Convention in the transnational context of 1958. But the New York Convention also has a provision that says the court can check the merits if arguments are made that something violates the ordre public, the public policy, but which is interpreted very, very narrowly. So I'm saying, well, let's give this a little bit broader interpretation. Maybe not every state will be held up to enforce everything. And then, of course, we want to think about dealing with the externalities that we're creating. One of the things that I've mentioned when I was in Davos, I said, well, you know, why don't we just drop limited liability protection for shareholders, especially for polluters? If we really want to make sure that people internalize the cost of the that they impose on the environment and others, then maybe it's not enough that the corporations pay the bills because they can go bankrupt and the shareholders can walk away with their profits. We could think about limiting limited liability for them. There's been a long debate in corporate law that limited liability for tort actions is not a good idea because it does create incentives to incur these kind of risk and these damages. It's a license to do harm and to profit from doing harm, right? Different story maybe for contractual creditors because they at least knew that they were contracting with the corporation. But that would focus the mind. I mean, people at Davos told me, well, then the markets will crash. Well, if the markets work only on legal steroids of this kind, maybe these are not the kind of markets that we want necessarily. And of course, if you want to make this change, you have to think about transition periods. And then, of course, you can think about other ways. Many of these tools we already have in our toolbox. You just have to reinvent them, put them in place, and you have to make sure that they stick, because many of them, of course, have also been limited over time. And then last but not least, I'm saying this is, again, a little bit provocative. I'm basically saying, well, you know, what you hear time and again, especially from the finance industry, is that what we need is legal certainty. Legal certainty, right? And no matter what you do, we need legal certainty. And I'm saying, well, maybe we shouldn't give you all that much legal certainty. Because legal certainty is also a way to engage in regulatory and legal arbitrage. And the uncertainty about, well, maybe we can caught on this stuff no matter what, right? Might keep people on their toes and think twice about the kind of strategies that they invoke. So all in all, for some, this sounds like, you know, minute little interventions. If you take them all together and you think about where we are and how we got to where we are today, it's probably a little bit more radical. I like to call it just strategic incrementalism. I think the purpose for me in writing this book and trying to think about solution was to find out where is the system vulnerable? Where are the soft spots here where we actually could push back without killing the system, but perhaps creating a better balance between our public interests and self-governance and the private interests in the coding of capital. Okay, let me stop here perhaps and get some questions.
Go ahead, raise your hand if you have questions.
Yes.
Hi, thank you. That was excellent.
Thank you.
I was just wondering, with your solution for it was empowering private parties to monitor capital.
Yeah.
Could you expand on that a little bit more? Because your sub-bullet, I was thinking that you were talking about a disclosure meeting.
Mm-hmm.
Did you
Yeah. No, I mean, disclosure is, of course, a condition for effective monitoring. I just don't think that disclosure delivers always on what we think it should deliver. I think securities regulation, this country in particular, many other areas are typically, we use disclosure and say, well, once we have disclosure, people can know what they're doing and they are rational actors and they can and respond to that. But I think, more is at stake than that, because you can disclose all kinds of things. We also live in a world of information overflow where you can't actually distinguish between all the things that have been disclosed anymore, whether it's executive pay and the underlying structures that we use and the models that we use to calculate that. So I think disclosure helps only the most sophisticated players and those that really have also the time to digest and then use that. And we often then create new shortcuts around disclosure, such as rating agencies and others, because there's no way we can digest this all. And I think we just need a couple of more bright line rules. And some of them are basically, and we need to empower some actors to not only monitor and then maybe adjust their portfolio, but maybe take legal actions. And for that, we need a little bit more, such as treble damages. So if I'm thinking about just let's take limited liability out. So who would be the actors now who would have to go and sue? Let's see, on behalf of the environment, you need to empower some actors, whether these are consumer organizations or states that suffer most from that. You would have to say, what can you do? And again, I don't think disclosure of the environmental damages that people have done is enough unless you have actually liability to having to stand in for that. So that's yes, in the back.
Hi, thank you so much. This is a really provocative discussion. So I want to ask a little bit more about this really profound observation that a single domestic legal system can prop up global capitalism. Because that, I mean, if you're somebody who wants to push back against that kind of global regime, the capitalist regime, that can be very worrying. It seems like if that's true, it would also be true that a single domestic alternative economic regime could prop up that alternative economic regime globally, because other, if you have a single socialist or communist or whatever economy, you could have people from all over the world contracting under those sets of laws. First of all, is that true? And second of all, what does that mean about, does this mean that there's like a sort of this meta-level market between capitalist economies and non-capitalist economies, and it just happens to be that capitalist economies are winning?
Yeah, no, I think this is a very good question. And actually, I haven't really thought about so much about thinking about an alternative legal regime that we could create that you can opt into, and people from other countries could opt into and use that. And but it's not far-fetched at all, because as long as we have these kind of conflict of law rules that give you choice, not only for contracts, but maybe also the ways in which you organize entities, companies, and then all the way to assets, in particular for intangible assets that have no location, right? You could create that. I have actually thought about this in concrete ways, but without making the link that you just made, interestingly. I've been working with Trevor Scholz, who is at the New School in New York, and he creates these digital cooperative platforms, and he wanted to know something about the law. So I've been looking into the law on co-ops in this country, or other types of legal devices, limited liability companies, and that we could use to create, let's say, a workers-controlled entity. And in theory, there are some states who have objections against that in their co-op laws, but in theory, you could basically buy into the co-op law of Colorado, which is one of the most advanced, even as you operate in many other states, not necessarily New York. So one has to actually, it's interesting to look at that, because when you look into this, you actually find that there are restrictions for alternative forms of business organizations that no longer exist in corporate law, that used to exist in corporate law. For corporate law in the 19th century in the US, the Commerce Clause was used to say you have to respect and recognize these legal entities from different jurisdictions, right? And for the most activist, let's say, capitalist types of entities, these things have been resolved long ago, and most of these vehicles, also limited liability companies, have become incredibly enabling or almost contractual. Under Delaware limited liability law, you can do almost anything. You can opt out of fiduciary duties, right? You couldn't possibly do this under a co-op statute. So I told these co-op friends, I said, well, use the Delaware limited liability company. You can do almost anything. They don't like this because it seems to go against their grain. It's like ideological, if they don't want to touch this thing. They say, well, if you can write a contract under it that works for you, it works for you. You could. And you could actually use even capitalist creature like the limited liability company in Delaware to do something very, 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 very different. In principle, yes. And you could do this outside. So you can create networks of other entities. But I want to say one thing. There are challenges to that as well. We also have a movement for public benefit corporations that basically declare upfront or sometimes midstream, but then need shareholders to buy out or something, that they want to serve not only shareholder value maximization, but a different goal. Now, there have been the first challenges in the Delaware court, although we haven't seen a decision yet, at least I'm not familiar with it, with one of them, where in a merger transaction, the shareholder said, now we want to have full maximization of shareholder value. Because all the case law in Delaware says, basically, you cash in when there's a merger. And the defense of the company was saying, we didn't want to merge with this company because it destroys the idea, the values that we've created with the public benefit commitment. So you can see that there will be these kind of conflicts, and you can see which side will have the resources to fight these. But there is room for legislature to clarify, I think, and give alternative organizational forms of property, whatever, and some leeway, I would say. Yeah. You were first, and then I come to you.
So thank you so much for an excellent talk. I just wanted to quickly ask, one of the things that you didn't cover, I just wanted to check in on, are the ways in which these private coding strategies have created wealth and also created a built-in constituency in the public law space. And so what we've seen in North Carolina, for example, is a Delaware company was spun off to own all of the hogs that live in North Carolina. That then was bought by a Chinese investment company, and which was approved by the United States government. Then the neighbors of that Chinese hogs sued them, and immediately legislators rushed into the legislature and said, oh, no, we have to restrict the property rights of the people living around these hog farms. They can't sue anymore for damages created by this. And so they actually restricted the property law rights of people who live near any facility that is an agricultural use. And so what's happened is you see a set of private coding that was designed to reduce liability, reduce exposure, and then when that fails because of a lawsuit, litigation decision, then they revert to a public law, and they actually are able to very easily outmaneuver in our current political system the voters.
Yeah.
So I just wanted to see if you had any thoughts about that. I mean, I think these are great strategies, but one concern I think I see is that with
You can't get them implemented because you have the legislators who work for the other side. Is that what you? Yes. Yeah. Yes. No, I can see that, and I think one thing that I found in my research and that I mentioned in the book, I probably could have made more out of that. You know, I'm stressing so much the common law, and I think until, let's say, about 25 years ago, most of these changers are pushing basically the limits of existing institutions, trying to use them for yet different purposes and designing all this in contract. The key change agent were actually the courts, the common law courts, because you could make your case, and then of course the judges who sit on the common law courts are recruited from the bar. In civil law systems, they come directly from the law school. You're either a judge or you're an attorney. You never switch, so very different mindset. But in common law systems, you have these judges who come from the bar. They know exactly what these folks are doing and also want to support them because they want to support economic entrepreneurialism and development, et cetera. But over the last 25 years or so, you see a shift from trying to push these things in courts to pushing them in legislatures. And there are several reasons for them. One important reason is that when you go back to this complex contractual structure with the securitization and the CDOs I showed you here, if you have one judge that then makes a new precedent, right, in the common law system, this collapses not only for this particular structure, but there are millions and millions of structures. If you get one wrong decision, this whole thing collapses, and we have created trillions of dollars worth of global financial markets on the base of these contracts. So the last thing that you want is actually a precedent. So what you see is that they go to legislature and lobby legislature. So the ISDA, they went, of course, to the EU and said, well, do you want to play derivatives? Then you need something like they have in the United States, so change your laws, right? So you need safe harbors for bankruptcy. Otherwise, you can't play in derivatives, and they got them, right? So that's typically the story that we see today, and we see this in different contexts as well. And in that sense, you're absolutely right. The legislature, of course, responds to the most powerful interests. And it's going to be difficult in many jurisdictions to make a lot of change. What I do say, however, in the book, ideally you, of course, would want to have the change in the US or in the UK, right? If these are the systems that code capital, if you change it there, we could change it a little bit. These are, of course, the last jurisdictions that will make any change because that's where you have the powerful interest, the lawyers and the financiers, right? So change has to come from somewhere else. And I think to some extent we could actually, this will cost something. Everything costs something. So I'm no longer in the Davos mood where everybody says, we can have win-win. No matter what we do, everybody wins a little bit. No, this is about allocating costs, and some jurisdictions might say, and we will take these costs. A little bit like Macron said last fall, and we will tax these digital companies. We will. Right? If the Americans don't want to come to the table and do a multilateral, we will do it nonetheless. Well, they cut a deal in Davos to say, let's just wait and try to do a multilateral again. So I'm encouraging basically individual states to go out and say, assert your sovereignty, and in states where you still have an ability of other constituencies to have a say it and use it. And yes, you might lose some capital coming your way, but you might also have a slightly more equitable society, and there's a price for it, right? It's democracy. It's something else that we might cherish, but just monetary return.
Thanks so much for coming to Duke. In chapter 9 of your book, and from your broader framework for strategic incrementalism, one of the proposals that, in the course of the quick talk, I think we didn't have a chance to touch on yet, was your proposal that because priority, durability, universality, and convertibility all depend on the state, that there could be room for, to use your phrase, the creative elevation of certain new forms of capital.
Yeah.
And in particular, in thinking about creative elevation, you talked about the elevation of certain contingent use rights. What would be some examples of contingent use rights that individuals who currently lack access to these codes of capital might have that could be elevated to create greater wealth for those groups?
Yeah, so what I basically was focusing on in my presentations is saying, well, how can we roll back the privileges that we have given one side? So we basically take out the bias again. But you could also go in the other direction and say, well, maybe we want to create some new types of rights. Why don't we, code certain other interests as capital, or encourage lawyers to code such other interests as capital, and thereby protect them and give them a little bit more durability. And one can think of different ways, and it's not only use rights. One of the things, for example, that has been discussed a lot in the development literature is Hernando de Soto's idea of giving property rights to squatters, right? With the idea that once they have property rights, they can take out a mortgage, they can fund a new business, they can lift themselves out of poverty. And what I'm saying based on the research I did for the book is that's not enough. Priority rights are not enough, especially for the poorest of the poor, but more generally, if you really want to create wealth, you need durability. You need basically an insurance device against shocks, exogenous shocks that you don't control. And the English knew how to do this. So after the English landlords had enclosed the land in their favor and driven off the commoners, they realized, of course, if they mortgaged their lands, the creditors would come after them and take away the land. So they entailed the land. They basically created a trust structure, very similar to this thing, where they basically said, the current owner of the land is not the owner, he's just the life tenant who holds the assets on behalf of future generations. With the result that under some medieval kind of statutes, the creditors could not enforce against the land or get only 50% and never the family mansion. That allowed the English gentry to hold on to the land until the end of the 19th century, when, of course, the whole thing crashed. At some point, it crashed because the creditors no longer give you money to roll over your past debt, then you have a depression. And then in 1881, finally, but that's at the end of industrialization, right? You have basically a feudalistic type of property rights regime in England all the way through the 19th century. In 1881, the Land Conveyance Act and the Land Settlement Act finally changed it and says the life tenant is treated as an owner, and we will take the land away and can go on the auction block. After that, within 20 years, I forgot exactly the numbers, but a huge amount of land changed hands because the land that had been held only by 8,000 families finally was put back on the auction block. Right? So what I'm basically saying to De Soto and co, property rights is not enough. You need durability, and then create durability, right? That basically means, of course, if they commit fraud or do something bad themselves, they should lose their land. But we should also have basically some kind of an insurance protection. One did this in the US in the 19th century, and to some extent also even in the 1920s, debt moratoria, right? We used to bail out the debtors, not the creditors. That's a choice. It's a huge political choice. But even in the 19th century, not every state would give a debt moratorium. Most likely were the states that were on the western frontier, where there had not been a lot of accumulation of capital yet in the hands of anybody, no vested interest. But in the states where you had major landowners, they would never fall for a debt moratorium because the landowners very often were the creditors. And in the states where they had the financial capital, Pennsylvania, New York, et cetera, you would also not have a debt moratorium, right? So, but you can, from these, what I'm basically saying, let's just look at these cases in history and see how we can have a more equitable distribution of rights and interests. Another way of thinking about this is, many of you might know this piece by Reich from the 1960s, the new property. And then there's a new property, but basically what he's saying, many people live off government largesse, which is basically what we call sometimes social entitlements. That could also be property rights with the effect that you can't just take them away anymore. I mean, sometimes if you have real reliance on that, we don't really take it away. But in principle, the state can say tomorrow, no, you get this, you won't get this anymore. Why give fundamental property rights to this and not to that? Who should decide? That's fundamentally the normative question here, right? And in our private law world, in the world of the capitalist economy, we have given a lot of decision-making power to private parties. And I'm basically saying we should think about how to make sure that we can give similar legal protection to others who might deserve. Yeah. Yes, I come back to you. Yes.
So I have a question about, so you mentioned about property and as data is like discussion about like treating data as property. And also you mentioned Sweden and Canada has like working on also establishing a new entity called data. So do you have any thoughts?
Yes. Yes, so as I mentioned, this is one of the frontiers of my current research, and I'm working with some research assistants and also a colleague who is both an economist and a technologist on these issues. So what is interesting to me is that, this property rights issue, how it has been discussed with regards to data, right? So there is a tendency by some jurisdictions saying we should vest the individual producers of information with property rights, right? And then they can sell it to the companies. The problem, of course, with that is that the amount of money we would get is so low, and especially if we're exposed to monopolist platform providers, the likelihood that we say no, unless we get 0.0 whatever cents on whatever information we're selling now, doesn't really resolve the issue, right? But the intellectual debate is nonetheless interesting because many economists have argued we do not need property rights here because there's no market failure, because the data harvesters harvest data even without getting property rights, right? Which of course is a faulty argument because what they have been able to do, and they started this relatively early, their rights are protected once they have harvested our data, right? They treat our data a little bit like, the Roman law had this principle of res nullius, the idea of there's certain assets that have no owner, like wild animals have no owners, but once you capture them, they're yours. So the data companies have used the information that we produce, like wild animal, arguing that once we capture them, they're ours, and you don't have anything. And then on top of that, they will say, your information is not worth anything. It becomes worth something only once we have cleansed this data and organized it and can use it for a running algorithm through it. So the value creation is actually on our side, it's not on your side, right? It's like similar with the wild animals. So once you have to cook it first before you can eat it, right? That's basically the argument that they are making. There's, however, another Roman law principle, and that goes to the question that you were asking, which is the idea of a jus communis. There's certain types of interests that should not be appropriable, which means, and you cannot create private property rights in that. And I think the ideas of thinking about public trusts, is to say the data that we create should not be owned by anybody. Giving individual private property rights will not resolve the problems that we have. Allowing the private parties to appropriate them at their pleasing is unjust. It also amounts to a form of taxation without representation or say that is problematic. And maybe we should try to create institutional structures that create them as a kind of a public trust. This is the debate that is ongoing. Whether this will really work and who would manage the trust and how would they create access rights and who would have access rights, these are all things to be worked out. But that's, I think, where this would be headed.
That's one.
Yeah.
Thank you for the excellent presentation. I thought I'd ask a quick overarching question. which really is the coding clearly creates wealth in the ways that we have demonstrated. The presentation was perhaps not quite explicit about how the coding creates poverty.
Yeah. So good point. So because I'm saying the subtitle of my book is how the law creates wealth and inequality. So how does it do the other side? I'm basically saying by having a strong bias for capital, is everybody who does not have that is left out. So everybody whose interests are not protected is subject to the normal ups and downs of business cycles and other disasters, which is, again, going back to the DeSoto example, if I give people property rights to their huts in a squatter's city, they will lose them if they can't make their payment. They will lose them tomorrow if they can't make their payment. And they might not be able to make their payment not because they overestimated their own ability, but there might have been a collapse of international markets and they lose their jobs or something else, right? So the inequality results from the fact that some have access to this additional protection from basically the whims of living and the whims of the world and the whims of international markets, and others don't, and those who don't suffer from that. I would add to that, and that goes back to an earlier paper I wrote in 2013 about the legal theory of finance, is that we tend to enforce our contracts and legal rules as written on the periphery of systems that ultimately are very hierarchical, but we relax or suspend those laws and rules at the core in order to protect the system if push comes to shove. So in times of crisis, we're typically trying to protect the core so that the system will survive, but we have no hesitation to enforce obligations on the periphery. Think about homeowners versus banks and things like that. So this differential application of the law is both an indication of how we create wealth and leave others in poverty, but also in how we create hierarchical power relations in our world.